An important question that I get asked from successor trustees is, what's the first thing I'm supposed to do when I find out I'm a trustee of someone's trust? Like, what am I doing? I'm lost. I'm confused. One of the first things a trustee has to do is, of course, read the trust, have death certificates. I feel like that's obvious. But the first act of administration is something known as a notification by trustee. It is a letter. It is probate code 16061.7. And this letter goes out to all beneficiaries listed in a trust and that person's heirs. So what I mean by that is typically that person's children, even if they have disinherited that child. So this sometimes starts bringing things really up to the front and we start getting a whole bunch of problems. But you have to notify them because they have the legal right to know that they are not receiving from an estate they normally would have received from as an heir of the person who passed away. They have to be put on notice. So your job as a trustee is to first notify all the beneficiaries so they know, hey, you're a beneficiary of a trust. Here's a copy of the trust. Now you know I'm the trustee. Now you know what you're getting. I will be connecting with you once I'm able to get that to you. We want to make sure you're doing that because it also starts a statute of limitations timeline for 120 days to contest the trust. That is why disinherited heirs need to be notified, because in case they feel that there was any wrongdoing, the person didn't have capacity, maybe had the dementia, Alzheimer's, they were heavily medicated, they were in a coma, we've seen that, they were unable to actually do this, we want to make sure that that person can prove that this trust is invalid. Now, we take all the precautions we can, but there are plenty of times that beneficiaries, heirs, people that are no longer beneficiaries, believe that they are entitled to an estate that they've been disinherited from. They just don't like that their parent didn't leave them anything and they want to contest the trust. So they're going to claim their parent didn't have capacity. Their parent was forced against their will, whatever that looks like. But that timeline is 120 days. That is why the trustee needs to send this notification letter within 60 days to everyone. And then the clock starts running. Okay, you want to contest the trust? Here's your time frame. But if you don't do it before that time frame and your time goes out the door, out the window, you don't get to jump back in 6 months later, 8 months later, 9 months later, a year later and go, you know what? I want to contest the trust. You had your time. So this is important because it does protect the trust and the trustee. We do want everyone to be notified. Legally, they should be. But we don't want people having unlimited access to contest a trust whenever they feel like it. So this is really important. There are plenty of times I've met with trustees. I had one recently, 25 years, have never administered the trust, never notified beneficiaries, never removed the home from the trust, just been paying bills on a dead person. Nothing. They haven't done any administration. The taxes alone are gonna kill them because it's gonna be 25 years of no reassessment and nothing happening with the administration. So there's going to be a lot of responsibility there on the trustees. So they're going to have a rude awakening. As a trustee, you also don't want that. So with that being said, if you are a trustee, you've just been appointed as a trustee, notification by trustee, probate code 16061.7. This is for California administration. You got to notify everybody. Okay? It has to be certified mail. Here's the kicker. I forgot to add that. Must be certified mail. If you don't do it certified, it actually doesn't count. Super important that it's sent certified. So that is your first routine act of administration. I gave that to you free of charge. I hope it is helpful because many trustees miss it.